If the VA provides you with a compensation and pension exam, they must ensure that that compensation, pension exam, and opinion is adequate. An inadequate exam or opinion may result in you being denied your case. If the exam is inadequate, though, you have options to appeal and get yourself a new adequate exam. Welcome to VA Made Easy. I'm VA accredited attorney and U.S. Army combat veteran Ed Farmer. Today, I'm going to discuss 7 reasons why your VA compensation and pension exam may be found to be inadequate. If you've been denied your VA disability claim and you're not happy with your VA disability claim, visit me at vetlawoffice.com. Not only do we provide zealous advocacy, I have access to VA medical nexus opinions. I'll prep you before your C&P exams. I have legal investigators to help you obtain those buddy statements. Sign up for a free consultation at vetlawoffice.com. But for now, let's get into it. All right, so the first reason why your VA C&P exam may be inadequate is the examiner may not be qualified. Make sure they're actually a medical professional. Generally, you want an MD or a DO or a physician's assistant or a nurse practitioner performing these examinations. Next, make sure that they're trained in the correct specialty. Generally, for mental health conditions, you want a psychologist or a psychiatrist performing that examination. You don't want a dermatologist taking a look at your orthopedic case, so make sure they have the correct specialty. Also, make sure they're trained by the VA. The VA requires examiners to go through a certain amount of training so they understand VA rules and regulations. They understand how conditions are rated, and they understand how to fill out the exam form. All the examiners must undergo that training in order to be C&P examiners. The second reason your VA C&P exam might be found inadequate is the examiner didn't consider any relevant late statements that you submitted. This is a huge problem. I think I have this issue in more than half of my cases. If you submitted statements from friends, family, coworkers, people you serve with, they have to consider that. So maybe you have your spouse discussing your PTSD symptoms and how it affects you at home and how it affects your relationship with their. If the PTSD C&P examiner did not consider that statement, then that exam is inadequate. Maybe you submitted a statement from your buddy who witnessed you get injured in service. If they did not consider that statement, that's an inadequate exam. The examiners must consider statements. Now, if for some reason the VA regional office found those statements to be not credible, then they do not have to consider them. But for the most part, I do not see the VA regional office deeming statements to be not credible. Remember, a good witness statement is somebody who was capable of observing that event. So they're capable of observing in you what your symptoms are. They're capable of observing what happened in service. That is a credible witness. The third reason why your C&P exam may be deemed inadequate is the examiner fails to provide a rationale for their conclusion. So they cannot just give a conclusory statement as to whether or not they find your condition related to service. So they can't just say, I don't think his needs are related to service. They have to give a rationale or explanation as why they think that. If they do not, it's an inadequate exam and you're entitled to a new opinion. Fourth reason your C&P exam may be found inadequate is the examiner is deciding non-medical facts. It is not the place of the C&P medical examiner to decide non-medical facts. That is up to the VA adjudicators. I see this all the time when it comes to PTSD cases. The examiner will say something like, I think his PTSD is less likely and not related to service because I don't believe the stressor happened. That is not their place. That is up to the adjudicators to determine whether or not that stressor is adequate. And that goes for all non-medical facts is not the place of the C&P examiner to decide non-medical facts. The fifth reason why your C&P exam may be inadequate is the examiners rely on an inaccurate factual premise. So let's say you apply for service connection for your back, and the examiner says, I think it's less likely than not their back conditions related to service. They only went to be seen for their back in one instance and never went back again. And in fact, there are 6 instances of you being seen in service for back injuries. That is an inaccurate factual premise. The VA cannot rely on that medical opinion. The 6th reason why your exam may be inadequate is the examiner uses the wrong evidentiary standard. So typically, the evidentiary standard in VA claims is the benefit of the doubt rule. That means that there has to be a 50-50 likelihood that your condition is related to service. So if the negative evidence is equal to the positive evidence, all else being equal, they're supposed to find in favor of the veteran. That's where that as likely as not standard comes from. That's 50-50 probability. Sometimes the VA examiners use a different standard, like the medical certainty standard, which is higher than 50-50. They cannot do that. Read your C&P exams carefully. Look at what standard they're using. If they use anything else besides the as likely as not standard, that is an inadequate exam, and you're entitled to a new one. The 7th reason your VA C&P exam might be inadequate is the examiner says he cannot form opinion without resorting to mere speculation. This is just a cop-out by the examiners. They have to explain why they cannot form an opinion based on mere speculation. Is there other information they could get to form that opinion? Can they perform other tests? Can they go out and get another medical evidence? Or more likely, can they ask the veteran the information they're missing so they can form an opinion? They can't say they're unable to provide an expert opinion without resorting to mere speculation without explaining why that is the case. So what do you do if you think that your exam is inadequate? Well, if you think your exam is inadequate for one of these reasons I stated, and it's been less than a year since you've received that adverse VA decision letter, then the best thing you could probably do is go out and get a higher level review. File VA Form 20-0996. You could ask for an informal conference. You could explain to the higher level reviewer why you believe these are inadequate. So if it's been more than a year, a supplemental claim might be in order. You could simply explain to the VA regional office, hey, this last exam I had, even though it's been a while, was inadequate. That might be enough to reopen the claim and get you a new exam. You might need to submit some additional evidence just for them to reopen it, but a supplemental claim might be your option. Or if you've been spinning your wheels at the VA regional office, maybe you already did a higher level review and the higher level reviewer didn't really help you out too much, you could go to the Board of Veterans Appeals. The Board of Veterans Appeals really understands the law when it comes to these exams a little bit better. So you do have a greater chance of success. You just end up waiting a little bit longer. Get yourself some help. Hire an experienced VA accredited attorney or representative. If you need help, visit me at vetlawoffice.com. But for now, keep liking, keep sharing, keep subscribing. And as always, you have the power to change your VA claim.